What is the process for carrying out an arbitration? Some of the general things that happen in this process, whether voluntary or mandatory, is generally you're going to have to decide on the subject matter of the arbitration. What is the exact nature of the dispute that you're trying to resolve? That if you're overly broad in that, it can be subject to challenge, or if you're overly narrow in that, then an arbitrator can make a decision or award that goes beyond the scope of their authority, and it could again be challenged. So the scope of the arbitration is really important to determine that front. Next, how do you choose the arbitrators? Okay. Generally, it will limit the selection to a potential group or class or certification of individuals, and then you'll have a procedure in place for selecting the arbitrators. The most commonly used form is one party selects one arbitrator, another party selects the other arbitrator, and then the two selected arbitrators select a third arbitrator. This is really common. You have an odd number of arbitrators, so you don't have a tie when it comes to voting for how you're going to hand down your award or decision. But also, it eliminates some level of bias there to have each party select one and then have these two independent arbitrators select a third. Okay. After you've selected the arbitrators, you need to submit the case to them. All right. So you generally enter into an agreement with the arbitrators as to the rules they're going to use, the extent of their authority, et cetera. It's going to lay out all of this in the process for submitting the case to them. Now, once the dispute or matter is submitted to the arbitrators, they are charged with scheduling the proceeding, dictating how things are going to go. Now, the rules and procedures that guide the arbitrators can be laid out in the document, but generally arbitrators are free to use the state of the law, the facts applicable to the situation, fairness, other operational considerations, industry standard considerations, things like that. Things that go beyond just the law in making their determination in resolving the dispute. And once they've resolved the dispute, they will hand down an award to the parties. It's not a judgment, it's an award. And the arbitrators generally don't have to justify their award or their findings with regard to the dispute. That would be voluntary. Now, sometimes the arbitration agreement will say, hey, the arbitrators do need to give an opinion letter as to why they found a certain way, et cetera. So if they do, they'll follow that and they'll write it out. But generally, without this requirement in the arbitration agreement or some statutory requirement from that, it's not required. And then after that, the parties seek to enforce the arbitration award. Now, each jurisdiction is going to have its own statute or procedure for enforcing the arbitration award. Okay, it could be registered with the court. In some cases, it has to be sued upon to turn it into a judgment that way. Other situations, it can simply be certified. So again, that's going to depend on the general jurisdiction where the arbitration is carried out.